don't know where you are watching us from, but I hope you're doing amazingly. And this was a great discussion with Ala and Joss, and we are also going to have a great discussion now. So I will try to introduce the subject quite quickly. So as we have repeatedly mentioned since the forum started yesterday, one of the online spaces where Palestinians are mainly discriminated against are social media platforms. As the so-called BSR report, an independent study commissioned by Meta, acknowledged in 2022, the company's content moderation policies and practices lead to the censorship of Palestinians and pro-Palestinian voices online. Nowadays, when speaking about social media and content moderation, you almost automatically will need to refer to the drive for legislation that is taking place throughout the world at both the international and at the domestic levels. The European Union has been a leading actor in that regard. The EU was looking forward to articulating a firm response to what was perceived as the digital Wild West, shaped by big tech companies located far away in Silicon Valley. That is how the digital decade of the European Union came to be. Critical texts were adopted. Everybody has heard about the famous GDPR, the General Data Protection Regulation. Well, I guess Meta will say that this is an infamous text after being fined a record $1.3 billion for mishandling user information when transferring user data from Europe to the United States. And in terms of other texts, the Digital Markets Act was signed into law in 2022, and the Artificial Intelligence Act will most probably be adopted this year. Sarah is an expert in that, one of our speakers. Correct me if I'm wrong. When it comes to content moderation, the jewel of the crown was the Digital Services Act. We are going to be referring during the conversation to the DSA, lauded by some as a constitution for the internet. It is crucial to mention and emphasize that these texts, but also other texts which go hand in hand with them, have and will have an unquestionable impact beyond the European borders, across the global south, and particularly on Palestinian digital rights. This is why we thought this session was essential for this year's SPIDAF, and this is why we invited brilliant speakers able to contribute with their different perspectives, experience, and insights to a very fruitful discussion. We have with us Sarah Sander, Senior Policy Advisor at EDRI, European Digital Rights. She leads the organization's work on artificial intelligence and non-discrimination with respect to digital rights, and this is something that I love about her work, interested in the indispensable links between digital and other social justice movements, mainly anti-racist movements. Sarah, thanks so much for being with us. We have Dania Abulhaj, legal officer at the International Center of Justice for Palestinians, an independent organization of lawyers, politicians, and academics whose principal objective is to coordinate legal work which supports the rights of Palestinians throughout the world. And the ICPP has been involved for years in the struggle to put an end to the censorship of Palestinian voices across social media platforms, mainly when it comes to Meta. Dania, thanks so much for being with us. And last but not least, we have Giovanni Fassina, Program Director at the European Legal Support Center, a partner organization, and an organization which defends and empowers advocates for Palestinian rights across mainland Europe and the United Kingdom through legal means, both offline and online. And we've been working closely hand in hand in these last years. So without further ado, I'll start with Giovanni. I hope you're okay with that. And as I was mentioning, what was clear from the beginning is that the DSA, this famous DSA, will be a game changer with far-reaching implications well beyond European jurisdictions. Could you mention some of them, some of these implications closely related to the work that ELSC has been doing these last years to defend Palestinian and pro-Palestinian freedom of expression in Europe?
Yes, first of all, thank you so much, Itchaso and Amle, for inviting us today. It's very honored and happy to be here. So basically, I think that a term that is central to the DSA is that of illegal content, because illegal content is not defined by the text of the DSA. However, each member state will decide what should be considered as such. So they left a lot of discretion. And each member state will issue a request so that social media platforms can take down this illegal content. However, social media companies are also required to monitor their own platforms. So this discretion is potentially is problematic, especially given the different sensibilities in each European country when it comes to allegation of terrorism or anti-Semitism. Because one of our biggest concerns when addressing Palestinian digital rights in Europe is indeed the weaponization of anti-Semitism through the application of the very controversial ISRA working definition of anti-Semitism, which basically demonizes almost any legitimate criticism of Israel. The definition itself, the IHRA, which is a short paragraph, is not problematic. What is very problematic are some examples of the IHRA. These examples basically were just attached to the definition, and through a wide interpretation, conflate indeed criticism of Israeli policies with anti-Semitism. For instance, writing and saying that Israel is an apartheid state can be considered anti-Semitic under the IHRA extended definitions. So these examples, although are not even adopted by IHRA itself, are basically treated by institutions such as the European Union and many governments as if they were part of a definition. And this is the result of years of advocacy and lobby from pro-Israeli organizations. So when it comes that each member state will decide what illegal content is, this indeed is very problematic, because I can envisage like state like Germany, for instance, that officially adopted the ISRA, to basically to use it for determining what content are illegal or not. And we saw this already because, like, for instance, in Germany, what we know, but we need to do more research, is that right now we're even, like, say, using IHRA for training police forces. Okay, so we can definitely see this being exported also to the online world, I would say. And this indeed it's highly problematic. Um, and also, another thing is problematic is that we have knowledge that a number of organizations trying to influence the adoption of the DSA to explicitly include references to the IHRA. And again, also this can be very problematic. So in view of this growing issue, and regardless of the advances of the many pros of the DSA, we predict that in cases of Palestinian or pro-Palestinian content, platform might seek to limit their liability instead of prioritizing contextual analysis, leading to further over-moderation. Because indeed, the IHRA is a very vague definition. That's the whole point. So using such a vague definition really paves the way for huge discretion. And this can really harm Palestinian digital rights, I think, we think.
That's really interesting. Thanks so much, Giovanni. I really like how we can actually identify the thread between what's happening, all of this discrimination of Palestinian content or Palestinian defense of human rights in Europe offline, and what's already happening online and will happen online, according to this idea, to this vague definition of illegal content, and who's in charge of asking the platforms to take down this content. As you say, it's police forces, right? So we clearly see the link there. Sarah, it's your turn. So Amnesty International just published a magnificent report called Automated Apartheid, which casts light on how third state companies are complicit in the violation of Palestinian rights as a consequence of the use of facial recognition technology. The EU seems intent on regulating AI technology inside its borders, but not what is produced in its member states and used to harm populations abroad, as it is the case with Palestinians. I am thinking of the Dutch firm TKH Security that is mentioned actually in Amnesty's report. What can or should European institutions do in this regard?
Thank you. Now I'm unmuted. Do you hear me? Yeah, great. I was just saying my thank you for the invitation, and thanks to Giovanni for the excellent points. What I will speak about is actually the other side of the coin to digital censorship, which is also, as you mentioned, the increasing prevalence of surveillance technologies to police us, to predict things about our movement, and particularly to punish and target and surveil. And particularly what we have tried to do is look at the impact of the use of surveillance technologies on racialized communities. And for example, of course, this applies in the case of the Palestinian people. So, as you've mentioned, Amnesty International, but also various other research over the past few years has been looking into the increasing testing, but also the deployment of facial recognition, but also other surveillance and other predictive technologies used in the Palestinian territories. And this is, I think, a really important piece of work that is going on. How can technologies and how are technologies being tested, deployed, used in various ways to fit into broader regimes of policing, broader regimes of surveillance, and broader regimes of control? The Amnesty report is a really good sort of first picture of like, okay, how do we map what those technologies are? So of course we see facial recognition technologies, not just to identify people one-to-one, but also broadly to identify certain areas and target interventions against people in particular ways, but also other types of technologies that aren't about individual identification of people, but more broadly used to, for example, surveil particular areas to see if there are people there as part of other regimes to control movement, but also predictive risk assessment technologies. All of these types of systems, we're seeing them pop up in various sort of places across the world. And what I think is the crucial thing to look at them there is that, of course, as we hear many times, technologies are not neutral, right? They always fit into broader systems of surveillance, broader sort of ecosystems of control, broader contexts of structural racism, for example. So when looking at these types of technologies, I think it's important to understand what they are, for example, facial recognition technologies, but also to understand them as carceral technologies, as pieces of systems, of tools that are used as part of the punishment and the discrimination of certain people. The question about the EU's artificial intelligence legislation is a great one, because in theory, more and more regulation of these types of technologies should be used to prevent harm against certain people, but also to safeguard their rights. This is actually one of the intentions of the EU's artificial intelligence legislation, but the question is, how far does this help people in the global south? How far does this help protect the rights of Palestinians? That's the key question here. What the EU's AI Act does is it puts several sets of safeguards on certain types of high-risk technologies. They include types of technologies used like facial recognition technologies, but also AI systems used in migration control and policing. So very many similarities that we see increasingly deployed in Palestine. Instruments of control, technologies of control. The question is, how far do those potentially useful rules that are stemming up in the European context, how does that actually help protect Palestinian rights? What the EU's AI Act does is it does propose some prohibitions on some of the most harmful types of technology. And that includes the use of facial recognition to identify people when they're in public spaces, but also a series of other types of technologies. Currently, one discussion we're having now is the potential ban of predictive policing technologies, which I understand also have shown up in Palestine to some extent too. A lot of the arguments that were being used are discriminatory arguments. These systems are discriminatory, they cannot be fixed, and they harm already racialized, already marginalized, already overwatched communities. There are two sort of question marks that I think we're left with in terms of the EU's AI Act and how can it impact Palestinian rights? How can it help potentially in the context of Palestinian rights? The first question is more of an opportunity and a hope, but it doesn't reflect yet into the EU's legislation. So the first thing is in terms of scope. The EU's AI Act, which could be potentially useful in the context of other places, is that unfortunately the piece of legislation is limited in scope. So first of all, these rules that we're talking about should either apply when surveillance technologies or any type of AI systems are either developed in Europe within the EU's borders, but also used in Europe. That leaves sort of a question mark around when certain pieces of technology are developed in Europe, as you mentioned with the Dutch company, but then deployed elsewhere and used in other contexts. Simply put, the question being, if a harmful technology is developed by a European company in Europe, but then exported and deployed in a harmful way in another part of the world, should that also be banned too? Currently, the EU legislation says no, this is not within the scope of this legislation. But what we're doing is trying to see, can we challenge that? Could that be a potential opportunity or avenue for advocacy for on Palestinian rights? Knowing that, and also as was highlighted in many reports, increasingly we can't make these arbitrary distinctions between where and when surveillance technologies are developed and tested and deployed. They are part of a global market of security systems, of militarized policing, of militarized surveillance that are not so easily carved out as regulated here and regulated in other places. The impact is the same. The impact is potentially harmful, more harmful in other places. So if we're setting certain rules for the European context, should we not also apply them in other places in Palestine too? That's the first question. How can we expand the EU's AI Act scope so that if something is harmfully banned, violation of rights in Europe, it should also be done so too, and to have some oversight of European companies for what they're doing and what they're exporting. The second question, and I think a little bit more of a more intrinsically linked, is also that the EU's AI Act takes some minimal steps to regulate the use of AI in migration contexts. That includes militarized border technologies, drones at the border, generalized surveillance, but also automated risk assessment. This type of sort of technology is inherently part of a broader instrument and regime of control and surveillance and interdiction of migration to Europe. And that can impact people traveling anywhere from outside Europe, but particularly from racialized communities and communities that we, again, know that are already under surveillance and control. So the second question and second opportunity and potential sort of avenue for Palestinian rights advocacy is also, how can we have a more critical, how can we have a more powerful approach to migration surveillance technologies, punishment technologies used in migration control with this piece of legislation? I'll stop there, but I think we identified two sort of opportunities, two potential avenues, but still a huge question mark of how useful they can be used in the broader struggle for Palestinian rights.
Thanks so much, Sarah. That was amazing. And yesterday we had a discussion. There was a session also on surveillance and on the multidimensional system of mass surveillance. And the question was just exactly the opposite. Why shouldn't we ban something that is tested on Palestinians and afterwards is exported in Europe and all around the world, such as Pegasus? Whereas nowadays we are speaking about software, tactics, logics, because at the end of the day, everything belongs to the same principle, as you say, these carceral technologies that are being designed in Europe but exported elsewhere in order to also curtail and infringe upon basic rights. And if something is harmful in Europe, it's going to be harmful everywhere, right? That should be the principle of any legislation. So yeah, this is an open discussion. I think we will keep having that. Thanks much, Dania. So besides merely regulating what will happen within the European Union, one of the goals in Brussels was also to inspire relevant legislation of other states through the so-called Brussels effect. They lack this term in order to emphasize the soft power and their influence all throughout the world. But the United Kingdom and other countries has been one of the countries following suit. The country's many governments in power these years have been shaping a text inspired by the DSA, the Online Safety Bill, which also addresses content moderation issues and will require social media platforms to remove illegal content. What can you tell us about how the text might impact, or is for sure going to impact, Palestinian digital rights?
Hi. Thank you all for the great points that were made. Thank you for inviting me to speak on this panel. Yeah, as you said, the UK's online safety bill has primarily been inspired by DSA, keeping in mind that the UK was one of the main drafters, or was involved in the drafting of the DSA anyways. So when Brexit happened, they wanted to draft their own online safety bill, which was very problematic over the years. However, it's now a little bit less problematic to say. Still has problems to be addressed, which I'll address later. But over the years, and in response to engagement with a broad range of stakeholders, the government did make a large number of amendments affecting specifically clauses 8 and 9 of the online safety bill. However, we do have the two responsibilities or requirements, which are preventative measures and content moderation. They remain in the main body of the bill. And the most problematic aspects with them, as it is with the DSA, are the definitions. The definitions remain unclear, sometimes indicating that they might rely on other definitions, like the high HRA definition, which might become problematic if we're adopting examples, as Giovanni said, that that are related to the RHA definition. One of the most problematic parts of the bill was the legal but harmful content, which was going to basically censor Palestinian voices or pro-Palestinian advocacy. However, the bill did actually drop the imposition of what they called the duty of care on major tech platforms. However, they did replace it with the Ofcom ensuring that the platforms uphold their terms of service and enforce these terms of service, or otherwise face criminal sanctions by Ofcom. Therefore, the risk of over removal of protected speech remains in place, as experience shows that companies will want to eventually limit their liability exposure and generously remove vast amounts of legal content if there is even the slightest chance that it could be in breach of their terms of service. I believe that the most problematic aspect is the environment that this bill provides for service providers and content hosting services companies. Punitive measures imposed here and there might risk that these platforms move into a more restrictive and censorious environment that might eventually lead to affecting pro-Palestinian content and Palestinian advocacy. So eventually, the threat of criminal liability, some vague concepts and definitions that underlie the duties to be upheld by this bill increase the risk of platforms relying on automated tools and removing protected speech in a precautionary and censorious manner. So these remain to be the concerns that are introduced by the UK's online bill.
Thanks so much. So we see some shared concerns, right, with the DSA, but I'm really appreciative of how you emphasize the difference between illegal content and harmful content, because this is something that was also discussed during the negotiations for the DSA, right? Illegal content is something that is illegal in each jurisdiction when it comes to the DSA and according to UK law, whereas harmful content is even more vague, right? It's who decides what's harmful and what's to be harmed, and which principles are to be, protected against this idea of harmful. So yeah, thanks so much. Apologies, because I know that my sound wasn't working okay with the headphones. That's all on me, and so apologies to all of you. I believe the problem has been solved now. So I'll go with Giovanni again, and in line with this idea that Sarah was bringing up of carceral technologies in which social media companies have started having a role, right, a growing role as actors responsible for e-policing and discriminated and censoring Palestinian and pro-Palestinian voices, right? So the DSA might change that or not, but Yomani, what do you think about the role that these social media companies have? At the end of the day, they are the ones who are receiving these requests by governments or by other trusted flaggers, as the DSA calls them. So they have this huge responsibility that Dania was also mentioning, right?
Yes. So I think that I think that hand in hand also with the DSA, it's important to highlight that we have indeed like this regulation 2021-784, which is called TRIG, and which address the dissemination of terrorist content online. And this is relevant for this discussion because we saw exactly in the implementation of this regulation how the trusted flaggers have been exploiting another very vague definition of terrorism for censoring Palestinian content, basically. Because for those who don't know it, this text constrains any internet intermediary to remove within an hour any content reported as terrorist. And so when assessing the potential impact of this regulation on Palestinian digital rights, we realize that the text might lead to further over-moderation and so censorship of content related to Palestine. First and foremost, because we are aware, also thanks to the really good work of Amle, of the close ties and relationship between Israeli and European law enforcement authorities. And we know that are mainly the European law enforcement authorities who are in charge of ordering the removal of online content. So companies will have to abide by this decision, and so most likely they're gonna delete most of this content. So moreover, this regulation incentivizes platforms to use automated content moderation tools. And there is so many evidence to show how these actually adversely impacts the rights of vulnerable communities in general, and Palestinians in particular. Because right now, like social media companies do not provide full transparency and regular updates around their legal obligation with regard to what are like considered foreign terrorist organization, for instance. No, so we don't have right now enough information about the company's content policies and how they are actually applying this regulation. But again, like it's clear, especially after the BSR report, that many Palestinian content was censored in the light also of the allegation of terrorism. And indeed, it's not a coincidence that the Meta's oversight board announced some time ago that it has accepted a request from Meta for an advisory opinion on the approach of moderating the Arabic term shaheed. When used to refer to individuals, it classifies as dangerous, right? Because as you probably know, like the Arab concept is always translated as martyr, right? But this is not. I mean, it's not fully accurate because Palestinians regularly use this terminology to refer also to people who just die under Israeli military occupation. So most of the time is not used for glorifying violence, and nonetheless, there was a blanket policy of just deleting any kind of comment which was mentioning this term. So again, when it comes to so to go back to again to your question for discussing, yeah, I mean, absolutely, companies are e-policing content, and I would say the only positive thing of DSA is that in theory there are implementing there are going to be very clear obligations about transparency and due diligence on the companies. So in theory, we will be able to assess whether governments and social media companies are guaranteeing the respect of citizens' freedom of expression. And so we will get to know which kind of content is deleted and which is not. And the DSA actually acknowledges the possibility of CSOs being involved in companies' risk assessment and risk mitigation measures. And so we really hope to be able to be more engaged on this and really understand which kind of moderation, which kind of e-policing is taking place.
Thanks so much, Giovanni. I'm really looking forward to the DSA, to publishing all of the transparency reports so that we can have access to this information that has been denied for so long regarding the censorship of Palestinian voices, but also other marginalized or vulnerable communities. So Sarah, now it's your turn again. So I have to share with the public that you are one of the stars responsible for a project that I loved, which is called Decolonizing the Digital Rights Field in Europe. The vision of the program is aligned with the voices of experts that call on the need for an intersectional, and we haven't mentioned still that word 35 minutes after the start of the conversation, an intersectional lens when enforcing the text, all of the text that we mentioned and others. You have worked for years on how different actors across the digital realm censor the voices and violate the rights of vulnerable communities. So can you let us know how this applies to our understanding of the impact of European legislation on Palestinian digital rights and, of course, other communities across the global south?
So in essence, like we can frame it like this. So you've already mentioned everyone on the panel has somehow mentioned in a certain way that European type legislation on tech or digital rights have in some way implications on people across the world, and particularly in the global south, either by those unintended consequences of those pieces of legislations, or maybe intended consequences of those legislations, or by complete ignorance of the real situation of people and the rights of people across the world. So starting from that sort of point, we actually also have to see this a regime where sort of the centers of power make legislation, make decisions that in some way impact certain communities of people. That's where we started. That's a starting point for the decolonizing process and program, which was essentially like looking at the concept of digital rights, especially digital rights activism in Europe, and trying to understand what, even putting aside the question of EU legislation, when looking at digital activism in Europe, specifically what we're looking at, but I think this applies to many other places in the world, including in North America, what power structures do that type of digital rights activism embed? Who do they ignore? Who do they center? And what are the harms that can come from that type of centralization? We particularly found that actually when we're looking at sort of the power structures in digital rights activism, we can kind of look at the problems with that in two ways. Number one, we can explore, okay, how does a very sort of exclusive form of digital rights activism wrongly characterize the harms? But also, number two, how could the responses to those harms be improved? And so that, I think I'll talk through the answer a little bit in those two frames. Firstly, in terms of the harm, so when we look at sort of increasingly, we're trying to look a little bit more about like how digital rights issues, whether it be in terms of censorship, as Giovanni has talked about, whether in terms of like broadly content moderation and freedom of expression, as Dania has talked about, but also in terms of like the tech and surveillance tech question, we see sort of like a disproportionate, like over surveillance in many different ways and disproportionate harms of certain racialized communities. Already that is something that is, I think, under considered, even within the European context, right? So we look at predictive policing, we look at facial recognition. There is a problem of disproportionate harm to racialized communities in Europe. What we also found is that actually a decolonial sort of approach would actually understand actually that this is a global problem. We have to view tech in the context of ongoing colonialism, ongoing structural racism, and Palestine is a really good example of that. Just as we highlighted the links between development, testing of technology between an inside and outside Europe, and particularly in the context of Palestine, we also have to understand that all of these harms that we're talking about are a global issue, but cannot be divorced from these contexts of colonialism and structural racism. So that's sort of the first sort of like way we're trying to understand this, is actually from a digital activism perspective, we cannot have approach that doesn't have have a perspective of racialization, and we cannot have a Eurocentric approach to the harms of certain technologies, certain centralization of power in terms of big tech. We cannot do that. So that's the first thing, is like thinking more broadly about like characterizing the harm in more global, more thorough, more critical ways that also center racialized communities in the global South, Palestine included. The second sort of point of, okay, how do we respond to the harm? What we found is that actually when we're looking at sort of a more sort of either intersectional or anti-colonial perspective to tech justice, one problem we were finding in Europe is that we were looking at very reformist ways of addressing these types of technologies. So even if from a very global North perspective, a lot of conversation, for example, around facial recognition, as we very much know, was about how we can make these technologies better. Or predictive policing systems. How can we improve these technologies? How can we remove bias from these systems? Increasingly, what we saw is that if we were going to have a critical perspective to these technologies, what we need is to not think about the bias of these technologies. That is one particular issue. But acknowledge that when deployed in a context of structural racism, when deployed in colonialist extractive, when deployed in a context of settler colonialism, those technologies, those systems, even those platforms, will almost inherently reproduce harm that is disproportionately impacting certain communities. So taking a little bit of a step back from actually trying to reform those systems and make technical tweaks to those systems, actually rethink at what is the purpose of these systems? Do we want to reform them, or do we need to abolish certain harmful carceral technologies and actually redirect resources that go into these policing tools toward actually things that make us safe, that meet our needs, that end oppression? So that was one type of solution we were thinking about in terms of responding to the harm. The other thing is also thinking about, as I said before, not viewing these harms as locally focused, but just understanding that just as these forms of production, the production of harmful technologies is a global enterprise, so must our coalitions be too. So one thing that we've been trying to address in the sort of European digital rights space is why is it that we actually see different frameworks of human rights when it comes to European digital rights versus other digital rights? We cannot do that. The global surveillance industry does not make these sort of regional distinctions, and neither can we. So what we need is transnational coalitions. What we need are global frameworks of solidarity. We need to question our dubious relationship with reform and thinking about, like, we cannot seek justice making small tweaks to certain technologies, but we have to sort of view them in broader racist frameworks. And then only then can we actually hope for a broader sort of helpful approach to something like EU policy. We can't have an EU legislation, for example, on surveillance technology or censorship that would help people across the world if we don't ourselves as activists, as digital activists, also critically evaluate our own practices and make transnational coalitions. So with that, I'll stop, but I think that I'm really interested to see a little bit more about how we can build some of those transnational coalitions.
Thanks so much. What you just said is so powerful. And when you spoke about, this reformist approach and, this technical twist, made me think about also how the companies, every time they need to defend themselves for accusations of censorship, they always mention these technical glitches, right? It's just about, figuring out, how to change that. And when the algorithm is going to be perfect, there's not going to be any kind of censorship or discrimination. Whereas, as you said, this seems to be something systemical that is also also linked to the business models of these companies, and this is something that we should reflect much further. And we might have time to discuss that afterwards. I would love that. Thanks so much, Sarah. Dania, back to a structural problem, because the UK and Israel have signed recently, I think it was a month ago or something like that, the 2030 roadmap for bilateral relationships, aiming, this is what is written on the page, to boost economic and technological geopolitical ties. That sounds perfect. It is not European legislation per se, but for sure it is going to have an impact on Palestinian digital rights. So could you be so kind as to explain what should be our main concerns? And I guess there are many in this regard.
Yeah, yeah, there are definitely so many concerns related to this roadmap. I'm not. There's not enough time to go through all of them, so I'm just going to go through two main concerns that we have here. One is concerned with digital rights, and one is concerned with the surveillance and the climate that this roadmap perpetrates for human rights abuses. So if reading through the roadmap, section 2C, and I quote, says, Israel and the UK will explore opportunities to work with government, civil society organizations, and tech companies to address the proliferation of anti-Semitism and Holocaust denial and distortion online. Both sides agreed to conduct a yearly dialogue on anti-Semitism and Holocaust remembrance. The goal of these meetings will be to exchange knowledge and explore possible cooperation, end quote. Reading through this, I think brings us back to the main points that are of main concern for everyone working in the UK on Palestinian rights. We are facing the risk of the rapid normalization of using the Hayat Array working definition of anti-Semitism without recognizing the censorship it imposes on individuals who have opinions, legitimate criticism of Israel and the human rights abuses that it is committing, and that we're seeing, they're increasing on a daily basis. Therefore, we are creating an environment where this is normalized as the standard definition at this point. The other issue that we have with the roadmap is basically Israel and the UK will work closely now in what we can refer to as an interpenetration of both business and intelligence operations, in particular when it comes to cybersecurity. This will allow Israel to have a higher and more intensified ability and increase its surveillance of the Palestinian people. And this is also extremely worrying, seeing all the surveillance that has been happening over the past few years. So these are the main 2 points that are of concern, related to the session's topic for today.
Wow, yeah, thanks so much, Dania. I didn't read the whole text, but I was already afraid that it might go along these lines. And yeah, I have mentioned that, of course, the floor is open for the questions from the public. I will spend 1,000 hours asking questions to these brilliant panelists, but I think we don't have time. And I always like to give a little bit of time and the opportunity to the audience, to the public, to ask these questions. If not, I'll ask them myself. We have 10 minutes left. So, but I think it's something that was mentioned, Sarah mentioned, this idea that we need to create international and transnational alliances in order to figure out the way in which we confront these tech companies, which at the end of the day, they don't have borders themselves, and they decide in the north, in Silicon Valley, as I was mentioned, what's going to happen to the people, to all of the people throughout the global south, without taking them into account. And this is also something that I wanted to ask you, whether any of you, have had their opinions taken into consideration regarding the global south when a legislation has been adopted in the global north. This will be interesting, because this is something that we have seen that is clearly and sorely missing. But besides that, what would be your opinion on international and transnational alliances, and how can we do that besides just beautiful words? Because those are beautiful words, creating networks, creating synergies in order to actually, try to confront these anti-Palestinian and anti-other vulnerable communities discrimination that BDAF is speaking about, and that we have been experiencing and researching and monitoring every day at Hamle and in other organizations. Do you have ideas? Because at the end of the day, this is also a brainstorm to steal your ideas away from you and do our own work. Giovanni, do you want to go first?
Yeah, no, thank you. This is really good. Good question in a sense that, but first and foremost, I think that like network and coalition can be really effective, and especially if we set this in a decoloniality framework. This can be effective only if the coloniality brings solidarity, and solidarity is something concrete, real. It's not just like a word. And I'm saying this because, to be honest, like I mean, our experience so far with the digital rights world, besides AMLE, was not being like great. We have been working on a case in Germany where a scholar, her name is Anna Younes, she was surveilled by an organization that monitor anti-Semitism. And because this organization used the IHRA, they prepare a secret dossier about her, where they monitor her social media posts, her publications, her academic publication. And this organization named RIAS, they framed her as an anti-Semite, and they got her disinvited. So we sued this organization, for violation of privacy. And to be honest, like we did this in Germany, and so honestly, like it was so difficult for us because we didn't get any major like digital rights organization or expert who was willing to support the case, because like we're suing an actor which is quite important and relevant in Germany. So again, I think again the coloniality comes from and proper work comes only with solidarity. If we can really work together on this issue. So I really hope we will have possibilities in the near future where we can meet in person and discuss more cases or advocacy effort that can be done among our organizations.
Yeah, I think I'm like, the only thing I can say in that regard is that me myself, I'm going to push. This is part of my position to push for that, and to actually push for meaningful coalitions, and I've received support so far from digital rights organizations everywhere in Europe, because this is what I do. So I think this is something that we can discuss afterwards. But Sarah, coming back to that question, how can we meaningfully, actually use the full potential of this idea? I know intersectional is already, a controversial term, but maybe you use anti-colonial, which I love, or decolonial. But how can we do that? In the boundaries that have been created for us by funders, by donors, by institutions themselves. Do you think I don't know, there's not a magical way, but maybe you have a recipe or something that you can share with us, because you've been working on that for years.
I definitely don't have any recipe for that, but I can tell you some things that we've been thinking of that I would really love to see. And I think it links already to what Giovanni just said. So I think the first thing, really, I think with any movement, any meaningful solidarity, like any meaningful like coalition, really has to be like, how do you center the most affected in the activism? And actually, I would really love to see more, I think in general, in terms of digital rights activism, but that is led by affected communities. I really do think we need more of an infrastructure. We need more resources. We need more attention to go to organizations like Hamle, who are working both on the digital rights perspective, but also fundamentally situated in the issue itself, the social justice issue itself, right? And that's only, I don't think we should see digital rights ever as a silo. And I think that's really the only way we address that, is actually have first and foremost the strategy, the power, the assessment coming from the organizations directly representing those most affected. So that's the first thing. The second thing would be, actually, how would digital rights organizations, but also international, also global north, European, human rights, digital rights organizations support those directly affected? And that's, I think, the question that requires many steps, right? It requires addressing internal racisms in those organizations, in addressing other power structures in those organizations, and also a fundamental willingness to actually do that support. Not being the main actors, but actually giving meaningful support to other organizations who know what the problem is from their direct experience. So that's another thing about, like, okay, what internal work does the international human rights space need to do, but also European digital rights space specifically need to do in order to be a meaningful solidarity, in order to do meaningful solidarity, in order to be a meaningful partner. And then I think the last point, also relating to this concept of like real solidarity, is also beyond advocacy. What do we do? Like, solidarity networks are about like actually targeting the processes of production, targeting the instruments of discrimination, control, being critical, but also making actual movements on the grassroots that also reflect our advocacy. So just as we see in other spaces, you see direct activism to shut down sort of weapons companies across the global north that are also then having implications in the global south. I think the same thing also applies to those international and global security companies that are producing surveillance technologies that are harming people in Palestine and in other places. So also direct action, grassroots work to actually have a material impact on those technology companies as actors of production, as producing these harmful technologies. So these are some small thoughts.
Thanks so much, and these are super valuable thoughts. Again, we don't have the magical recipe, but we might be getting there just by reflecting together. I think Dania abandoned us. Maybe she had an internet issue, but we are 2 minutes away from the end. And I loved how you mentioned that digital rights shouldn't be a silo, because at the end of the day, digital rights are human rights, and this is what people working at digital rights have been mentioning. And it's not just about digital rights; it's about technology companies as a whole and how they behave and how they shape different contexts of punishing and incarcerating people in different ways. And also how every time we think about alliances and every time we think about solidarity work, it has to be meaningful, right? Dania, you had escaped, now you're back. So because you're also, we'll finish up with you. You also work in alliances, and you are also a partner of Hamlet in many of the things you do regarding digital rights. So do you have thoughts or advice, or do you think there's some things that work much better than others in terms of creating this meaningful alliance and meaningful solidarity?
Basically echoing the points made by Sarah and Giovanni, but also I think it's recognizing the problematic aspect of focusing on these things when there's so much happening when it comes to Palestinian rights. And I think in the UK specifically, it's a bit tough that not a lot of organizations are still working on it collaboratively together, and there's not enough pressure. But as we've seen with the case of this UK online safety bill, pressure sometimes actually does result in differences being made and amendments being made. And I just think when it comes to Palestinian digital rights, there should be more coordinated efforts being made with more organizations in the UK. That doesn't have to be specifically organizations working on Palestinian digital rights, just organizations working on surveillance and digital rights. We can include other people working on different sectors, just somehow related, and use their experience and use their expertise in advocating for these matters and these rights, and learn from their experiences. So yeah.
So thanks so much. That was super enlightening, and I will watch the video over and over again to keep learning from you guys. And yeah, I just wanted to point out that at the end of the day, we are all fighting the same beast in different shapes, in different forms, and with different means. But we need to be aware of that, and this is for me what meaningful solidarity and alliances is: being aware that we are actually struggling against the same beast in Europe, in Palestine, and all throughout the world. Thanks so much, guys. Again, I'm really appreciative, and yeah. Have an excellent day, you, the public, and keep on the good fight. That's for sure.
Thank you.
Thank you.
Thank you.